fourth subtopic, which is agency relationship, types of authority, duties of principal to agent, and types of principal. Agency. Agency is a legal term of art that refers to the relationship between a principal and an agent. Rating an agency relationship. An agency relationship is a fiduciary relationship where one person principal allows an agent to act on his or her behalf. Example of agency: employee and employer, lawyer and client, corporation and officer. Who can be a principal? Under Section 136 CA, any person who is 18 years old and above and who is of sound mind may be a principal. Types of authority. The first one is actual authority and the second one is apparent authority.
Actual authority exists when the agent takes an action on behalf of the principal and he reasonably believes that the principal wants this action taken. Actual authority includes express authority where the principal tells the agent exactly what to do. It also includes implied authority where the agent takes action reasonably necessary to accomplish the objective of the agency. Principal can also limit agents' authorities or revoke them as they choose. As an example, a principal who initially tasks an agent with purchasing a piece of real property may amend the instruction to limit the agent's authority to leasing the property instead. Apparent authority is when the agent takes actions for the principal with the third party that the third party reasonably believes the agent has the authority to take. As an example, principal hires an agent to manage his business. Principal tells agent that he can't buy more than 50,000 ringgit of goods from any supplier. However, a principal tells to a vendor that agent has unlimited authority to buy from him. Then agent buys 70,000 ringgit worth of goods from vendor. Agent has apparent authority to buy because vendor reasonably believes it is based on the principal's conduct.
In Section 175, agent to be indemnified against consequence of lawful act. The employer of an agent is bound to indemnify him against the consequence of all lawful act done by the agent in exercise of the authority conferred upon him. In Section 176, agent to be indemnified against consequence of act done in good faith. Where one person employs another to do an act and the agent does the act in good faith, the employer is liable to indemnify the agent against the consequence of that act. 3. Cause an injury to the rights of third persons.
Section 177. Non-liability of employer of agent to do criminal act. Contracts Act 1950, where one person employs another to do an act which is criminal, the employer is not liable to the agent, either upon an express or an implied promise, to indemnify him against the consequences of that act. Section 178. Compensation to agent for injury caused by principal's negligence. Section 178. The principal must make compensation to his agent in respect of injury one caused to such agent by the principal's neglect or want of skill.
Types of principal. What are the types of principal? Principal are categorized based upon whether their identity is disclosed to the third parties with whom the agent interacts on their behalf. Types of principal. Disclosed principal, partially disclosed principal, undisclosed principal are the types of principal in agency relationship which is involved in the act on its behalf legally. Disclosed principal. A disclosed principal's identity is known to third parties dealing with the agent, which means in the event the principal's identity is unknown and the third party has gathered enough information to conclude their identity. The agent cannot be held personally liable for any damages resulting from the breach because in the event the contract is breached by the principal. In a legal situation, the court will try focuses on protecting the third parties who are handling the asset of the principal. For example, I go in and say I am representing my client, Miss A, on her behalf.
Okay, so for partially disclosed principal, a partially disclosed principal is known by third parties to exist but the exact identity is unknown. This type of relationship exists when there is some benefit to the principal to remain anonymous to third parties interacting with the agent. For example, maybe I am representing someone big like Disney and I am buying some land for a new amusement park. If the seller knew it was Disney, the price will increase rapidly. For undisclosed principal, the existence of undisclosed principal is unknown to a third party. The third party believes that she is interacting only with the agent. This categorization of principal are important in determining the rights and duties of principal, agent, and third party. Notice, if in fact the agent was authorized to on behalf of the undisclosed principal, then the principal will also be liable on the contract and subject to indemnification. For example, here I go in and don't say a word that I am representing someone else.